Let me tell you about something that almost never happens in America. Right now, we are watching history unfold in a way that nobody expected. A former First Lady of the United States is about to face something no one in her position has ever faced before. She may soon be required to answer questions under oath. Questions about where she really lives, questions about her money, questions about her marriage, and questions about connections that powerful people usually keep hidden forever. We're talking about Melania Trump. And here's what makes this situation so unusual. This didn't happen because someone attacked her. This didn't happen because of politics. This happened because of a decision that her own lawyers made, a decision that has now put her privacy at serious risk. Right now, a federal judge is handling a case that could force Melania to answer questions that no First Lady has ever been asked in court. Where does she actually sleep at night? What do her tax papers say? Does she live in Florida or New York? And if her paperwork says one thing but reality says another, which one is the lie? This case didn't start as something huge. It started the way many Trump legal fights begin, with a threat. A massive threat meant to scare someone into silence. A threat that came with a price tag of $1 billion. But instead of staying quiet, the person being threatened did something almost nobody does. He fought back. He sued first. And by doing that, he walked Melania Trump into a legal trap that even a friendly judge might not be able to help her escape. What happens next is important for everyone, because this case is testing a simple question. What happens when powerful people are finally forced to follow the same rules as everybody else? Stay with me. This story is just getting started. Let me take you back to where this all began. It didn't start in a courtroom. It started with a letter, the kind of letter that has scared journalists and writers into silence for years. Back in October, a well-known investigative journalist named Michael Wolff got one of the most aggressive legal threats you can imagine. The letter accused him of lying about Melania Trump. It demanded that he take back everything he wrote about her connections to Jeffrey Epstein. It ordered him to apologize publicly, and it warned him that if he didn't, he would face a lawsuit seeking $1 billion in damages. Not 1 million, 1 billion. The message was clear. Apologize and disappear, or we will destroy you financially. The letter came from a lawyer in Florida named Alejandro Breto. He's someone who quietly works for Donald Trump's circle. This is the Trump playbook. You don't argue about facts. You don't debate evidence. You threaten people with so much legal pain that they give up before the fight even starts. And most of the time it works. People fold. They publish embarrassing apologies. They issue statements that sound like confessions, or they just go quiet and hope nobody remembers. That's exactly why this case is so dangerous for the Trump family, because Michael Wolff is not some random blogger. He's not a Twitter personality. He's a serious journalist who has survived years of legal threats and come out fine. He's written multiple best-selling books about the Trump White House, books that expose chaos Trump wanted buried. So when Wolff got that billion-dollar threat letter, he didn't panic. He didn't apologize. He didn't back down. Instead, he did something that flipped the entire situation upside down. He went on the attack. And that one decision is what turned a routine scare tactic into the legal disaster Melania Trump is now facing. What happened next is the moment this case stopped being normal and became explosive. Because instead of reacting the way the Trump legal team expected, Michael Wolff completely changed the game. He sued first. Think about that. Instead of waiting to be dragged into court under the weight of a billion-dollar lawsuit, Wolff went straight to New York State court and filed his own lawsuit before they could. This almost never happens in modern media law. And it was a smart, deliberate move designed to do one thing above all else: force everything into the open. In his lawsuit, Wolff didn't hold back. He didn't soften his words. He didn't quietly back away from anything he had written. Instead, he listed every single statement that Melania Trump's lawyers said was false. And then he explained one by one why each statement was protected. He showed that each statement was either backed up by facts from his reporting, or it was clearly his opinion, which the First Amendment protects, or it had been twisted out of context by Melania's legal team to make it sound worse than it was. But Wolff didn't stop there. He went further. He accused Melania Trump and her lawyers of using what experts call slap lawsuits. These are lawsuits that aren't designed to win. They're designed to scare people into silence, to drain them financially, to send a message to everyone watching. If you speak up, this is what happens to you. By suing first, Wolf forced Melania Trump into a position she has avoided her entire public life: participation. Now there are rules, deadlines, judges, evidence, sworn statements. This was no longer a backroom threat. It was now an active legal case governed by law and facts. The moment Wolf filed that lawsuit, the Trump legal playbook lost its most powerful weapon: fear. And that's when Melania Trump's legal team made a decision that seemed smart at first. A decision they thought would give them back control. Instead, it triggered the trap. Once Michael Wolff forced this fight into the open, Melania Trump's legal team faced a problem they're not used to dealing with. They could no longer rely on threats. They could no longer count on silence. They now had to choose where to fight. And that's when they made a move that looked clever on the surface. Instead of fighting the case in New York State court where Wolff had filed, Melania Trump's lawyers tried to move the case to federal court. This is a common move in big lawsuits. Federal courts have different rules and different standards. And in many cases, defendants think federal judges are more predictable and more careful than state court juries. But there was something else going on here, something more personal. Through random assignment, the case ended up in the courtroom of Judge Mary Kay Weiskachil, a federal judge appointed by Donald Trump himself. From the outside, this looked like a gift, a familiar name, a friendly judge, someone with a history of rulings that had previously helped Trump-related cases. To the Trump legal team, this probably felt like they were back in control: a federal court, a Trump-appointed judge, a chance to shut this down quietly before it became something bigger. And for a moment, it probably looked like the gamble had worked. But here's what most people don't understand about federal court. You don't just get to go there because you want to. You don't get there because you like the judge. You don't get there because it feels safer. You need jurisdiction. And jurisdiction isn't optional. It's a requirement. If you can't legally prove you belong in federal court, the entire case gets sent back to state court. Worse, the attempt itself can open doors that were closed before. By choosing federal court, Melania Trump's legal team unknowingly stepped on a legal landmine built into the court rules, one that doesn't care who appointed the judge, one that doesn't care about politics, a rule that demands proof. And in the next stage of this case, that proof would come at a devastating personal cost. This is where Melania Trump's legal strategy turns into a complete disaster, because federal court has one harsh rule that no amount of power or influence can change. If you want to be in federal court, you have to prove you belong there. The legal tool Melania's team used is called diversity jurisdiction. The idea is simple and brutal. Federal courts can only hear a civil case if the two sides are citizens of different states. If both sides live in the same state, the federal court has no power to hear the case. No exceptions. The case goes back to state court, period. Michael Wolff lives in New York. That's not in question, which means that for Melania Trump to stay in federal court, she has to prove she doesn't live in New York. Read that again. Not suggest, not imply, prove. By trying to move the case to federal court, Melania Trump voluntarily made her home address a legal issue. And under federal court rules, once residency is questioned, the other side gets an extraordinary right: limited jurisdictional discovery. This is the legal trap. Jurisdictional discovery allows Michael Wolff's lawyers to demand evidence, documents, and sworn testimony for one specific purpose: to figure out where Melania Trump actually lives, not where she says she lives, not where press releases claim she lives, where she lives in reality. And once that door opens, it can't be closed halfway. This isn't optional. This isn't fishing for information. This is mandatory process triggered by Melania's own court filing. Wolff's lawyers now have legal authority to send written questions, demand documents, and take depositions aimed at one question that controls everything: does Melania Trump live in New York or not? If she does, the federal court loses power and the case goes back to state court. If she doesn't, she must prove it with evidence that holds up under oath. Either way, she must answer questions under oath. There's no special protection here, no exception for former first ladies, no carve-out for political families. The rules work the same way for billionaires and regular people. By chasing what looked like a safer courtroom, Melania Trump activated the one legal process that exposes her private life to the harshest examination possible. And the questions that come from that one issue are about to get far more personal than her legal team ever expected. Once jurisdictional discovery is activated, activated, this case stops being theoretical and becomes deeply personal, because the law doesn't ask where someone says they live. It asks where they actually live. And to answer that question, Melania Trump now faces a level of examination that no First Lady has ever faced before. Here's what jurisdictional discovery really means in practice. Michael Wolff's lawyers now have the right to question Melania Trump under oath, not in a press conference, not through spokespeople, in sworn testimony where every word has legal consequences. They can ask where she sleeps most nights. Not symbolically, literally, which address, which bedroom, how many nights per year. They can ask how often she stays at Trump Tower in Manhattan versus Mar-a-Lago in Florida. They can ask when she last spent the night in the same home as her husband. These questions aren't gossip. They're legally relevant to determining where someone really lives. They can demand her tax returns, federal and state. Those documents don't care about public stories. They state explicitly where a person claims to live under penalty of law. If Melania has claimed Florida residency to save on taxes while actually spending most of her time in New York, that difference becomes explosive. They can request property records, lease agreements, utility bills, credit card statements, travel logs, anything that helps show patterns of daily life, where groceries are bought, where doctor appointments happen, where personal staff work. Residency is built from habits, not headlines. And here's the part her legal team can't escape. All of these answers must be consistent with tax filings, consistent with prior statements, consistent with any benefits claimed at the state level. Inconsistency isn't just embarrassing, it's legally dangerous. Every answer Melania Trump gives in this process is given under oath. A false statement isn't a PR problem, it's potential perjury. And even leaving things out can be scrutinized once documents start to contradict testimony. This is why jurisdictional discovery is feared by powerful defendants. It removes image control, it replaces spin with records, it replaces denial with sworn answers. And Melania Trump walks straight into it. What began as a defamation threat has now turned into a forensic investigation of her private life. And in the next phase of this case, one detail in particular threatens to destroy the residency argument completely. Her son. This is the detail that turns Melania Trump's residency argument from weak to potentially impossible to defend. Because jurisdiction isn't decided in a vacuum. It's decided based on real life. And real life leaves paper trails. At the center of this problem is her son, Barron Trump. Barron Trump is currently a student at New York University, located in Manhattan. That single fact carries enormous legal weight because universities don't just casually ask where a student lives. They require formal declarations of residency, and those declarations have consequences. At NYU, like most schools, there's a big difference between in-state and out-of-state tuition. The financial reason to claim New York residency is real, and the paperwork used to support that claim is specific. Addresses, how long you've lived there, where your parents live, tax information. So here's the unavoidable question now facing Melania Trump under oath. What residency was claimed for Barron Trump on his application and enrollment paperwork? If the Trump family claimed New York residency to get in-state tuition benefits, that directly contradicts Melania's claim that she lives in Florida for federal court purposes. You can't be a Florida resident in federal court while at the same time telling a university you're a New York resident. The law doesn't allow you to pick and choose residency based on convenience, and it gets worse. If Melania argues that Barron lives in New York on his own while she lives mostly in Florida, that opens another line of questioning. Why does a young adult live full-time in New York while his mother supposedly lives somewhere else? Who supervises him? Where's the main household? Where are daily routines based? Residency isn't about mailing addresses, it's about the center of life, where family life happens, where time is spent, where obligations are met. For years, reporting has consistently shown Melania Trump living primarily in Manhattan, shopping there, attending appointments there, maintaining a visible daily routine there. Closeness to Barron has always been given as the reason. Now, that same explanation threatens to collapse her legal position, because if Melania lives in New York to be near her son, the federal court loses jurisdiction. And the discovery that proves it becomes part of the public record. Barron Trump isn't part of this lawsuit. But his presence in New York may be the fact that makes Melania Trump's federal court strategy impossible to defend. Here's the most damaging irony of this entire situation. Even if Melania Trump somehow avoided the worst parts of jurisdictional discovery, even if every residency question went in her favor, the underlying defamation case is still incredibly weak. When you look at what Michael Wolff actually wrote, the legal foundation of Melania's claims falls apart almost immediately. Defamation law in the United States sets a very high bar, especially for public figures. And Melania Trump isn't just a public figure. She's a former First Lady. To win, she must prove that Wolff made false statements of fact, that he knew they were false or didn't care whether they were true, and that they caused real harm. Opinion doesn't count as defamation. Context matters. Documented reporting is protected. Now, look at the statements her lawyers attacked. Wolff wrote that Melania Trump had connections to Jeffrey Epstein's social world. That's not speculation. It's supported by publicly documented facts about modeling agencies, social circles, and historical events. He wrote that she may represent a missing link in Donald Trump's relationship with Epstein. That's clearly framed as analysis and opinion, not a statement of fact. Opinion is constitutionally protected. He referenced social overlaps and connections from the Epstein era involving modeling networks. Those are verifiable elements of the historical record, including Melania's work with a modeling agency that had well-documented ties to figures in Trump and Epstein's world. None of this is reckless lies. None of it is anonymous gossip. It's research-based reporting combined with interpretation. That's exactly what the First Amendment protects, which raises the question nobody can avoid. Why take this risk at all? Why expose your residency, your taxes, your marriage, and your private life to sworn examination in federal court to chase a case you're likely to lose on the facts? This is why legal experts quietly describe this as malpractice territory. Someone should have stopped this. Someone should have explained the risks. Someone should have said no. Instead, Melania Trump pushed forward. And now she's facing the most invasive legal exposure of her life to chase a defamation claim that may never even make it to trial. And in the next phase of this story, the question is no longer whether she can win. It's whether she can escape at all. At this point in the case, the most dangerous reality for Melania Trump isn't the questions she'll be asked. It's the fact that there's no clean way out anymore. Every option comes with serious consequences. One possibility is to voluntarily give up trying to stay in federal court and ask that the case be sent back to New York State court. But doing that would require admitting what would be obvious to everyone, that the removal was a mistake. A public acknowledgement that her legal team miscalculated and triggered discovery they couldn't control. That kind of retreat is rare in high-profile cases, and it invites even more scrutiny. Another option is settlement, but that door appears closed. Michael Wolff has shown no interest in backing down. He didn't sue first to quietly compromise. He sued first to force transparency, to set a precedent, to put the intimidation strategy itself on trial. Settlement would take away the very discovery that makes this case matter. Melania's team could try to limit discovery, arguing that questions about her personal life are too invasive. But federal rules leave little room for judges to be flexible on jurisdictional disputes. If residency is legitimately contested, discovery must be allowed. Judges don't get to ignore jurisdictional requirements out of sympathy or political loyalty. That leaves the most likely outcome. The case moves forward. Discovery happens. Depositions are scheduled. Melania Trump sits down under oath and answers questions about where she lives, where she sleeps, how often she's in New York versus Florida, and what her financial and tax records actually show. Her answers are recorded, transcribed, preserved. And once those answers exist, they don't disappear. They become part of the court record. They can be cited by journalists. They can be analyzed by investigators. They can be compared against public statements and prior filings. This is the nightmare scenario for a family built on controlling the narrative, Donald Trump has spent decades using lawsuits as a weapon to intimidate critics into silence. But this time, the weapon backfired. The legal system he relied on to suppress information is now forcing it into the open. And for Melania Trump, the clock is no longer counting down toward victory. It's counting down toward testimony. When you step back and look at what's happening here, the significance goes far beyond one lawsuit or one former first lady. This case exposes the core weakness of the Trump legal strategy that has worked for decades. It only works as long as nobody fights back. Threaten lawsuits, inflate damages, intimidate critics, drain them emotionally and financially. Most people give up long before a judge ever gets involved. And because of that, the facts never have to be tested. The documents never have to be handed over. The answers never have to be given under oath. Michael Wolff broke that cycle. By suing first, he forced Melania Trump into the one place the Trump world avoids at all costs, a courtroom governed by rules instead of leverage. In that arena, power doesn't come from money or threats. It comes from evidence, from consistency, from truth. For Donald Trump, this is the nightmare scenario, not because the defamation claims are strong. They're not because the judge is hostile. She's not. But because discovery doesn't care about loyalty or politics. It cares about facts. Where do you live? What do your records show? Do your statements match your filings? Those questions can't be spun. They can't be tweeted away. They can't be buried under threats. If Melania Trump testifies, her answers will become part of the permanent public record. If documents contradict those answers, the consequences grow immediately. What began as a defamation dispute turns into a credibility crisis, potentially a tax issue, potentially something far worse. And this is why this moment matters for everyone watching, for journalists who have been threatened into silence, for whistleblowers who were told the cost of speaking was too high, for citizens who were taught that powerful people never face accountability. This case proves something dangerous for entrenched power. The moment intimidation fails, the system flips. The rules apply, the questions come. The truth is demanded under oath. Melania Trump didn't intend to create this moment, but she did. Through a single strategic mistake, she opened the door. The discovery process is just beginning. Depositions are coming. Documents will be produced. And when sworn testimony starts, there is no going back. We're not watching speculation anymore. We're watching accountability in real time.